So Laura Akahoshi is the former Chief Compliance Officer at Rabobank. And one thing that's interesting about this action is that before that, she actually worked at the OCC as an examiner for over 10 years. And the OCC is now claiming that while she was at Rabobank, she lied to the OCC about whether Rabobank had received a report from an audit firm that concluded that Rabobank had a deficient Bank Secrecy Act compliance policy. So the OCC is really seeking two things. First of all, it's attempting to impose a civil money penalty of $50,000 against Laura Akahoshi. And second, it's seeking an order that bars her from participating in the affairs of basically any FDIC-insured bank, which effectively is an order that puts the end of a banking career to anybody who previously had worked in banking. And the OCC is seeking to obtain these penalties under Title 12, United States Code Section 1818, which authorizes banking agencies to impose a civil money penalty on a bank employee that engages in a violation of a law or regulation. So one thing that makes this case really unusual is the fact that the OCC is not just alleging a violation of a regulation, which is more typically what it does, but they're saying that Laura Akahoshi committed a federal crime. And so in this case, the OCC is bringing asserting that there's three different bases for the violation of Section 1818. The first is engaging in a practice that is contrary to the safety and soundness of the bank. The second is interfering with the OCC's ability to examine banks. And the third, and this is really what's unusual, is they're saying that Laura Akahoshi committed a federal crime by making a false statement to the OCC about the existence of this report. So the OCC's action in this case should be really concerning to compliance officers. Because in the past, bank regulators have really tried to create an atmosphere where compliance officers are comfortable sharing information and documents during the examination process. And in this case, it looks like the OCC is actually saying, look, if we ask for documents or we ask for information and we don't think that what you gave us is as forthcoming as we want or is the complete information, not only will we seek to obtain that information, and in this case, the document that the OCC obtained or requested, they actually obtained. The allegations are basically that the compliance officer didn't turn over the document for about a 2-month period, but the document was ultimately turned over. And the OCC didn't even claim the document contained information about what the bank had done that it didn't previously had. The only information that was in this report that the OCC is focused on is the conclusion that was reached by this audit firm, which is the same conclusion that the OCC had already reached. So it looks like it's a situation in which there's something like a dispute over whether the response was adequate. And in the past, nobody in that kind of dispute would have thought that there's a possibility that they would land up in prison. But now that the OCC is seeking to impose or allege criminal violations just for not turning over a document, I think this really could have a chilling effect on how comfortable compliance officers are going to be going forward when they get requests for documents from the OCC.